Alright, hello and welcome to another criminal law capsule, and this one is entitled The Practical Aspects of Causation. And in this capsule I'm going to focus on causation as an element of the actus reus. And in particular, I'm going to talk about something that I have noticed really in teaching the law of causation over the years. And what that is especially in the early going of law school, I find that students tend to overvalue or overestimate the importance of causation. And I understand why. We spend a lot of time on causation and we teach it in a way that sort of stresses how important it is. And really that's because it's a very interesting doctrine, and in certain circumstances it can be extremely important. But what I've found is that can be overemphasized to the point that students spend a lot of time analyzing causations in situations when it's really not that important. So what I want to do in this short capsule is sort of go through and explain the situations in which causation is really important and explain why causation really isn't that important in a practical sense in a lot of situations that arise commonly in the criminal court. So really, this is just an attempt to go through the practical aspects of causation to help you understand when causation is really essential to go through and when causation is really less important because of other aspects of the criminal law that really dominate or sort of, what I like to say, overwhelm the causal analysis. So I guess one way to start thinking about this is, let's say you take all the offenses in the world, and this is just sort of an attempt to sort of place the importance of causation in the relative sense. Well, the first thing you have to recognize is that causation is an attempt to analyze a particular aspect of the actus reus, which is that you cause a particular consequence. So right off, if you assume that these are all the offenses that there are in the criminal code or otherwise, okay? Well, right off, you have to recognize that, like, you're going to hive off, I don't know, let's say half of the offenses right away that have nothing to do with causation. And that's simply because these offenses don't have consequences. So any offense that does not have a consequence is simply not concerned with causation in any sense of the word. So to take an example of offenses that you've already dealt with, the basic offense of assault does not have a consequential element. It's proven when you intentionally apply force without consent. There is no need to prove that you have caused any particular harm. There are many other offenses that fall into this line as well. Impaired driving, which is a very time-consuming offense in the courts, possession of narcotics, most narcotics offenses, importation, etc. These are all offenses that have nothing to do with consequences, and therefore causation as an idea is completely irrelevant. So right off, accept that half the criminal code doesn't involve causation. But that's not really, the focus of this capsule. There is another reason why causation really is limited to a fraction, and I would say this is the fraction for which causation is still relevant. Now, why are these particular offenses eliminated as well? So let's use a different color, okay? These offenses are eliminated because they are practically irrelevant, or causation is practically irrelevant, and that is simply because of mens rea. And I'll go on to explain in another diagram why the mens rea element relating to the consequences simply overwhelms the need to prove causation. And the reason for that is, just to put it, I'll explain it, I'll show you exactly how it works in the next diagram, but just to put it as cleanly as I can, it is usually much harder to prove that someone intended to cause a consequence than it is to show that they physically caused a consequence, which is what causation actually tries to prove. So since it's harder for the Crown to prove this one than it is to prove this one, at trial the focus tends to be on the mens rea. Why would you focus on the one that's easier to prove? If the Crown can't prove the mens rea, it's not going to be able, it doesn't matter whether or not they can prove causation. In other words, strong cases of causation tend to be, or strong cases for the defense of causation, tend to be dealt with as mens rea cases. Let me show you what I mean. So keeping in mind that you haven't actually dealt with causation yet when you're watching this, or maybe you have, or maybe you haven't, but the likelihood is you haven't. But let's just explain that causation as an element of the actus reus is a fairly low standard, okay? You will come to see that you don't have to prove that a person was the absolute cause. You don't have to prove that the person was even the proximate cause. You just have to show that they were a cause. It's a little bit more complicated than that, but for the purposes of what we're doing, that's good enough. As long as they were a partial cause of what happened, that's good enough. Okay? So stay with me. So remember that for the actus reus, all you have to show is that a person was a partial cause. So most causation cases that you're really going to battle on, you're going to be trying to show that the accused really wasn't a cause at all. You're trying to show that the chain between the conduct that they did, which was, let's say, an assault case, and the harm that followed was incredibly weak. You're trying to show that the causal chain was weak. Okay. Now, in a murder case, you could focus on causation, but why would you want to bother? Because in a murder case, what you've already got to prove, or what the Crown has to prove, is full subjective intent. In other words, the Crown has to prove that the person intended to kill. Now, I realize there are some other definitions of murder, but, let's just stick with this one just for the purposes of simplicity here. If the Crown has to show that you intended to kill your victim, what's the point of focusing on causation? Here's why. The weaker the causal connection, the more difficult it will be for the Crown to prove that you intended to kill. It'll be almost impossible. Again, any case where you can show that your conduct barely or was a weak cause of the person's death, it's just going to be very hard to prove in most of those cases that there was any intention to kill. And that is always going to be true in any case where you need to show subjective proof of an intention to cause the prohibited consequences. So let's put this in even more concrete terms. Let's take a weak causal connection case, because most causal cases are pretty clear. You shoot a gun, somebody dies, there's no causation case. Let's take a case where you have you're trying to show a weak causal connection, some weak, crazy chain of circumstances, and don't take me here as saying this would or would not meet the chain of causation, because that's not what I'm trying to show. I'm just trying to show you that the weaker the causal chain of connection, the harder it is to show intention, which is, to me, where these cases are going to be won and lost for the Crown. Let's say you have a guy who's taking target practice, and he shoots a gun, and that gun hits a rock, and that rock, hits another big object and causes it to fall over and hit somebody. And that object was, teetering precariously because somebody left it in a bad way. Well, you could argue this as a weak causation case, because look how many crazy things had to happen for that person to die, okay, as the thing fell. But why would you argue it that way? Trust me that causation is a tougher standard to prove, because you only have to show that you were some cause. But, who's going to argue it that way when you could just argue that, look, Your Honor, look how many crazy things had to happen. That shows that my client had no intent to kill. And trust me, you're going to win that case every time, because look how many crazy things had to happen. You're going to win the intent case anytime there is a weak chain of causation. And that is why, as a practical matter, 99 times out of 100, I reserve the one time, which I'll come back to in my wrap-up, 99 times out of 100, weak causal cases where you have to prove a high intention to cause the consequence are going to be run as mens rea cases. And that's why, if you go back to my earlier diagram, 3/4 or 80% of the crimes in the criminal code, either because they don't have consequences or because they require subjective proof of consequences, don't really require any proof of causation as a practical matter. So to summarize, where does causation have little to no practical relevance? Well, where there's no consequence element, obviously causation has no relevance. And where the consequence element requires significant proof of intention, whether it's willfulness, intention or recklessness, I don't think it really matters that much. You could make a case that with recklessness, which is a lower standard, causation still matters, but I don't really think it does. I think it makes no difference. If you require proof of subjective intention, causation really just doesn't matter. So the key is, what do you require as proof of the consequence? Now, let's go on to the more interesting thing. When does causation still matter? There are 4 situations in which causation has practical relevance, though 2 of them are very rare. This is the first of them, and this is actually very, very rare. Here what we're talking about is absolute liability or strict liability offenses that require a consequence element. These do exist. There's no question, they do exist. You will see some provincial offenses that have consequence elements of harm involved. Well, obviously, if you don't have to prove any intention, causation matters. You want to be able to get off because you didn't cause the particular element in question. So if there's no mental element required, you better believe that fighting on causation is a really good idea. Yes, causation is important for these types of strict liability or absolute liability offenses where there is no intention required. Number 2, any situation in which the consequence element requires only objective foresight. Now, in these situations, it's really important. And one of the reasons for this is because of the way in which objective foresight is considered. Objective foresight considers probability. It doesn't look at what actually happened. This is very important to keep in mind. So, for example, when I'm conducting an assault, what objective foresight will look at is simply the nature of the force in question. And it will say, well, is that force reasonably likely to cause bodily harm? That's it. Was it reasonably foreseeable? That's what it is. Nothing more, nothing less. Causation looks at very different things. Causation looks at what actually happened. Now, this is a big difference. I want you to understand the difference between these two things. Sometimes an assault will cause bodily harm for weird reasons. Let's say, for example, that I swing at someone with tremendous force. Tremendous force, okay? But I don't hit them really hard. Let's say, I'm giving you a weird set of situation, but let's say I swing at somebody incredibly hard, but I only tap them on the chin, okay? I tap them on the chin. But they then have a weird set of circumstances where something crazy happens, I don't know, a hurricane, and for whatever reason, a lot of harm then befalls them. Now, under the mens rea portion of this analysis, we would look at whether my force was reasonably likely to cause bodily harm. And the answer would be yes, because all it would look at is the probability of the nature of my swing. And it would say, well, what was I doing? I was swinging incredibly, with a great deal of force, and that's what would have caused the harm. So under the mens rea analysis, I'd be guilty. But under causation analysis, I might escape liability because it would look at what actually happened and whether I'm responsible for what actually happened. So this is a situation in which causation still has practical relevance. Believe it or not, still fairly rare. Look how crazy the example was that I had to give you just to separate the mens rea of the probability from the actuality of the causation. Now, you want to see where causation has the most practical relevance? There's a reason why almost every causation case you'll read has to do with manslaughter. The reason is because the mental consequence element in these cases is different from the physical consequence element, and that's why causation matters. Because with manslaughter, the mens rea element is only objective foresight of bodily harm, but the actus reus element is causal proof of death. Now we have something here. In this situation, it's not that hard to show objective foresight of bodily harm, but you may have real situations in which you can show that despite the objective foresight of bodily harm, you weren't the actual cause of death. This is the situation where the differential between these two things is the strongest, and you're really likely to have a very practical place for a causation analysis. Finally, just to be comprehensive, there are exceptionally rare circumstances. Remember I said 99 out of 100, where you could have need to prove subjective mens rea. but the actus reus was still not caused by the person. So I'll just give you an example. Like, it's a crazy example, but that's what I have to come up with. I mean, a crazy example of a situation where a person clearly wants to kill another person. Like, they just do. They have all kinds of evidence. So that they have we have a confession. Yes, I wanted to kill them. Screaming to 12 other people, I want to kill them, I want to kill them, I want to kill them. They do everything to try and kill them, but they don't actually kill them. They only commit some basis of the killing, but then some other overwhelming act actually kills the person. It is conceivable that this could happen. You know, the person is driven to suicide, they want to kill themselves, some intervening act happens, but for whatever reason, the intention is present, but at the end of the day, the act that caused death was not present. They did an unlawful act to make them culpable, but they didn't actually cause the death, despite having the intention. Very unlikely that this would happen, but it is at least theoretically possible. In this case, what you'd actually have, believe it or not, is an attempt. You'd have an attempted murder, which is a big difference. You'd be punishable for a lot lesser penalty. But it is potentially important to show that the person didn't cause the death. Even though the intention is present from all the other evidence, they did not actually physically cause the death, and that is something you could show. But it's very rare that that would actually happen. In any event, I hope this capsule was useful to you to show you situations in which causation is actually useful and has practical relevance. And if you have more questions, you're always welcome to come and see me or send me an email. But that's all for now, so hope you enjoyed this and have a great day.